Hello and welcome to Legally Speaking with me, Tarun Nangia. This is a very special series. It is about Justice Suryakant's vision and mission to reduce pendency of cases via a very ambitious program that he is currently working on, which is called Mediation for Nation. And this is also very important because not only he has unveiled the program, but he's going to get it audited by the Judicial Academy at Bhopal, which is the National Judicial Academy, and give us output results. It would happen in the month of October. We are going to discuss all that and more on today's show. I have to welcome senior advocate Shashank Garg, who is traveling. He's somewhere in Europe, but he kindly and sort of in amidst his busy schedule, he made time. I'm thankful to you, Shashank, for joining us. We know arbitration is your true love, but I think even mediation is something that you would speak in favor of. I have with me senior advocate Sri Venkatesh joining me. I would have to mention he joins us sitting at the airport and joining us. But when I said it is Justice Suryakant show, we have to do it. He says, come what may, I'm going to join you. Thank you so much, Advocate Sri Venkatesh, for joining me today on the show. I have Advocate Vivek Jain joining me. Good to see you, Vivek. Thank you for your time. I have Advocate Anirudh Bakru, who joins me today from the city of Delhi. Good to see you, Anirudh, and looking forward to your insights. I have Advocate Siddharth Sharma joining me. He practices on the tax side a lot in the state of Madhya Pradesh at the High Court there, and sometimes in Delhi too. Good to see you, Siddharth, and looking forward to your insights. Specifically, you represent extensively the state of MP, where you sort of work on the tax side. Your insights from what's happening there, what can be done in that state, will also prove valuable. At the outset, let me request Senior Advocate Shashank Garg to make the opening comment on this issue. Over to you, Shashank.
Thank you, Tarun. I think the topic you've chosen is of paramount importance in today's time, and the drive that the Supreme Court has started, which is this 90-day special mediation drive. I don't think it can be compared to any initiative of any judiciary across the world. From the record that I have seen, 1.69 crore cases have been identified, which will be looked at for the purposes of mediation. And as many as 31,000 mediators are being put to use to do these mediations. I remember in the last 5 to 7 years, several mediation training programs were conducted by the Supreme Court, or at least with the help of Supreme Court by other international bodies. And the question that was posed to all the people who were getting trained was that where is the work for so many mediators who are getting trained? I think this project shows that we need as many mediators as can be trained. And I believe the success story of this mediation drive will lay down the groundwork for many such drives in the future. One very unique facet that I must compliment Supreme Court on is that the mediations are being actually conducted in regional languages. So it's no more just an English and Hindi trained mediators. These are regional mediators who, because in a family dispute or in a small commercial dispute, if the mediator can talk your language, that really gives that comfort to the parties to settle something outside of the court. So I think this is a very, very welcome step, a mammoth step, and I'm sure the success will also be resounding.
Thank you, Shashank, for your opening comment. I'll go at this point to Advocate Sri Venkatesh, who is very thickly, I say, in the sector, commercial sectors like the energy sector of India, where he has a view on what kinds of issues, what direction they should take. On a larger issue like mediation, how is it applicable to commercial disputes, and what does he feel about Justice Suryakant's vision and mission as far as disposal of such cases is concerned? Over to you, Venkatesh, for your opening comment.
So thank you, Tarun. First of all, I think the drive which has been undertaken by Justice Suryakant and the Honorable Supreme Court, in my mind, is an unprecedented move in any, at least to my mind, when I was doing online reading, whether any such judiciary of any other country has done something like this, I could not come across a judiciary-driven mediation process. Mediation typically is known as a process by which two competing parties can seek to resolve the dispute. It has never happened that judiciary has taken leadership of this scale and magnitude to solve pending disputes by identifying cases for mediation. To my mind, at least to my research, I could not come across such a large scale, endeavor taken by any country. So it obviously speaks volumes of what the vision of the Supreme Court today is in terms of trying to resolve these disputes in a more amicable and a simpler format as opposed to litigating them. So to that extent, I think we have very interesting times ahead, and I wish this project all the very best in terms of achieving the intended goal. Now that's on the larger scheme which has happened here. But in my experience in mediation, per se, especially when the matters are, either pending before dispute forums or in arbitration, an effort is made. But ordinarily, the effort is made only as a feeble attempt to see whether parties could potentially try and solve the matter before without asking the arbitrators to render an award. I think with this kind of an initiative taken, the arbitrators also, while adjudicating on disputes, although they are mandated to ask this question during the proceedings, would take it more seriously and would ask this question from parties whether they would be willing to settle the matter and appoint somebody, who is competent to understand the nature of the gravity of the dispute and arrive at a settlement. So I think it will have not just, of course, this is being done at a very large scale where certain pre-identified cases are being sent for mediation. Because there's going to be a general shift towards mediation, I foresee in times to come that this shift will also be felt in other areas where this is usually not taken, very seriously, because parties are more than happy with their bank balances to fight out a commercial litigation as opposed to mediating it. So I think that mentality change may happen in times to come. Tarun, you're on mute.
Venkatesh, before I go to Advocate Vivek Jain, wanted to highlight 1.69 crore cases shortlisted A and 32,000 mediators working to settle them. So
Yeah.
these are big numbers.
Big numbers, very big, unprecedented numbers, I would say.
Yeah. So this is something that is an ambitious plan, and sort of we get to see how we get to the results of this. I go to Advocate Vivek Jain for his opening comment on Justice Suryakant's vision and mission via Mediation for Nation. Over to you, Vivek.
Yeah, hi Tarun, thanks for inviting me. Now, as we all know, Justice Suryakant has donned role of a private litigator. Then he was an advocate general. So he has seen private litigation, he has seen government litigation at the highest level. Then he was a high court judge for over a decade. And then he has come to a Supreme Court. So Justice Suryakant has seen litigation all his life. Now, from such a person, a request and this kind of a pilot project coming for mediation actually speaks volumes of how much thought process has gone into it and how much data he would have seen to realize that this is something which can actually solve the judicial pendency of matters before various courts. Now, I think the rub lies in the data which I could see from the internet is that if you would see the kind of pendency we have and where we have this pendency. Now, pendency, if the data is right, then the district courts in India has a pendency of around 4 crore cases, which is around 85% of pendency we have in Indian courts. High courts, obviously, is around 65 lakh or 70 lakh cases, which is around 15%, and Supreme Court is negligible 1% of pendency. So if you see this data, then we can actually realize what would have went through Justice Suryakant's mind to actually, alleviate this kind of a problem and come about with some kind of a resolution to this. And the quickest way to resolve the pendency, according to me, would be mediation. Because courts are deciding what? Courts are deciding as to who was right yesterday. In mediation, you're actually deciding how in the future we both can be right. So I think if that is the approach and the kind of mammoth project, I think, which is undertaken and with such kind of a time scale where there is a time limit also, and then there is obviously a report by the Bhopal Academy, I think what Justice Suryakant has done is to actually make it very professional. He has also institutionalized it. As I have actually told in your earlier show, that we need a shift in mediation from voluntarism to professionalism, because as of now we would only see people volunteering for mediation, that okay, I'll do mediation after my court works are over. But then we have to turn it into a professional mediation ecosystem where a person is actually expertise having an expertise of mediation would go about with a mediation. And I think for that the whole ecosystem has to be built. And I think the fact that Justice Suryakant at that level and at that kind of a magnitude has started this, I think it speaks volume. And I can see the future of mediation in India is largely to grow. These were my opening comments. You're on mute, Tarun.
Thank you, Vivek. I remember that show on mediation itself when Justice Suryakant suggested mediation in regional languages. And Advocate Sri Venkatesh and you were there along with Justice Sanjay Kishan Kaur. It was widely appreciated. As we all say, Justice Suryakant has his ear to the ground, and that's why a lot of what he speaks sort of leads to, in a sense, now with this program, a lot of matters that can be decided quickly and settled will be settled via mediation. We are hoping for the best results. I'll go to Advocate Anirudh Bakru for his opening comment on Justice Suryakant's vision and mission for with Mediation for Nation.
Thanks, Tarun. I mean, look, we've never seen a process like this at this scale coming from the top with this kind of oversight. And I feel that this could actually be the answer to our pendency. We have a pendency issue in this country that's growing, cases are growing, and mediation is, in fact, an answer that can solve a lot of it for two reasons. The majority of our pendency is actually in district courts. So you can actually mediate a case, you get rid of an appeal and you get rid of subsequent appeals so that those cases don't travel, they end there and then. The canvas of mediation is always larger. In one dispute, maybe 3 to 4 different cases can get settled because parties can always go beyond. Now, to explore that as a system and have this kind of oversight, impetus from the top, trained mediators, I think if done right, is a great initiative, can go a long way into finding a solution to a problem of pendency.
Thank you, Anirudh, for your opening comment. I'll go to Advocate Siddharth Sharma. Siddharth, what is the view from Madhya Pradesh, where, of course, there is a huge pendency there as well? Can you bring in some insights also because you practice a lot on the tax side? What is the potential on the tax disputes front as far as mediation is concerned?
Arun, it's my first time on your show. Thank you so much for having me over.
Yeah.
It's very kind of you. So, regarding the local ground level state of situation in the state of MP, see what happens is most of the disputes, they do not involve a very high quantum, to answer your question specifically. So what happens is when the quantum of a dispute is not high and there are disputes of smaller scale, then both the parties, they have to incur expenses on a lawyer and other kinds of legal expenses. So when this keeps on going on, that both the parties are incurring costs, that costs may somewhat foreshadow the actual amount of dispute involved, and it may lead to a stage where the issue becomes an ego issue because both the parties have heavily invested on litigation cost, and now it is no longer a issue pertaining to the limited dispute at hand because the dispute may be of a smaller quantum, but since the case has lingered on since so many years, there are so many grudges, there are so many investments in terms of litigation costs, and also the time that is invested of both the parties. So after years of suffering, it may not be even worthwhile to pursue that litigation. So as you opened in the start that you were looking forward to some kind of suggestions uh, that can be attractive for the state also to come forward with this kind of a thing. I think it is to identify disputes which are on the verge of the point of no return, wherein mediation is the only way. It will be a mutually assured destruction for both the parties to continue. Because unfortunately, in some cases where the pendency takes a lot of time, the case itself becomes a suffering for both the parties. So in the end, even if one party wins, the other party loses, the quantum may be of a very small magnitude, but both have already done their end of suffering. So it's a mutually assured destruction in most of the disputes at a very smaller level, looking at the long delay in court cases and the pendency we have. So perhaps if such disputes are firstly identified and looking at Justice Suryakant's vision, the fact that, as it was also highlighted by Mr. Jain regarding the background of your lordship, which is heavily influenced by your lordship's experience, also, lordship is a true leader. In fact, he thought about the whole country and he looked at the district courts also. It shows lordship's commitment to identifying the disputes at a ground level and to take care of the poorest of the poor sections of the society. So I think if on these lines we proceed further, we are looking at bright future, also taking into account the fact that even before joining, Lordship has already spoken so much on this topic. So it gives the outline of the eagerness on part of Lordship to take action as soon as possible for the betterment of our system. Thank you.
Thank you, Siddharth, for highlighting the aspect of poor people, because it is they who bear the brunt of endless litigation. They have no money even to sort of pay lawyers, and if it's mediated and settled, it helps the courts also. I'll go to Senior Advocate Shashank Garg for his best wishes to Justice Suryakant and one suggestion that he would want to give for this program specifically.
Thank you, Tarun. One aspect that Siddharth mentioned, I think we know that India is a very litigious society, and everybody thrives on litigation or getting their day in court. This sort of a drive and the success of this drive can actually bring that shift in the mentality of the entire society. If this drive reaches its objective, which I'm sure it will, if 1.69 crore cases have been shortlisted, even if 50% of them see the result of this mammoth drive, this can have an impact that will have a long-lasting effect on the mentality of the society itself, which has not seen mediation as a effective measure of adjudication so far, and especially in commercial disputes. I mean, family matters and other small matters, mediation has been useful. But in commercial disputes, India has so far not matured. And you pointed out in the beginning, the government of India is not viewing mediation as a serious option for commercial dispute adjudication.
Yes.
That is something that requires a rethink, that requires some further tweaking in the policy. As you know, the Mediation Act specifically says that it would not apply if one of the parties government of India, unless it is a commercial matter. So for these initiatives to find success and to be adopted in continuity, I think there is also some tweaking required at the policy level within the government, because this mediation should be seen as the first option for
Yes.
dispute resolution by the government.
Thank you for that closing comment, Senior Advocate Shashank Garg. I'll go to Advocate Sri Venkatesh. Advocate Sri Venkatesh, any such initiative that the judiciary takes needs the support of the bar in a wholehearted level. Given that this program will extend into the whole of next year after this output report is out, this is what we are expecting. What is your one suggestion to Justice Suryakant and your good wishes as your closing comment?
Thank you, Tarun. My suggestion would be that, I did the math. 1.69 crores and 31,000 mediators would effectively mean about 500 odd cases per mediator. So I think the idea should be that if the idea is to achieve the intended objective, perhaps more mediators may be required in the next weeks and months to come to see that result. And more particularly, this is something we spoke about, I think, in the last show, which Vivek and I was referring to, is that training or the baseline training of these mediators is something which we all are concerned with, because ultimately the mediators must understand and exercise caution in terms of how they approach the two parties when helping them arrive at a settlement. They don't take, I mean, there is a huge gap between deciding a dispute and mediating a dispute. Mediating requires you to arrive at a consensus, and that itself is a very different kind of an exercise. So therefore, training is something that that's one suggestion, that if it could be standardized or some format could be prepared in which the mediators also understand what is their exact role in these proceedings. And largely, the third and most important point, for these 1.69 crore cases identified for mediation to be settled, I think there should be enough public awareness to understand that if a mediated result is arrived at, then that result is binding on parties. And this is something perhaps a lot of litigants, as Siddharth was referring to, at the rural parts of the country may not be aware. They are more aware of a court system where you go to court, you get justice, or you lose and you go forward. Whether you can get the intended result through mediation and whether that's binding or not, I don't think that's, as a matter of fact, known at large scale. So perhaps an awareness. So awareness, perhaps more standardized process in terms of mediating, and lastly, more mediators may be required if this year is to be spent in resolving these disputes. These are my suggestions, and I'm wishing Justice Suryakant and the entire Supreme Court machinery who's conducting this whole process all the very best, because this is something which is we desperately require in our judicial system.
And indeed, we are happy when a judge is communicative, much less, I mean, he's the judge of the Supreme Court. He's communicating that not only will I work, I'll give you my report card. That is something which is heartening to hear. Advocate,
Yes.
your closing comments and wishes for Justice Suryakant.
Well, I think one of the important things which I think we should also do is to recognize mediating as a skill. Like we all talk about advocacy as a skill. We'll say that this advocate goes to the court and handles the court well. He understands the subject. So it's very important for us to actually recognize mediation or mediating as a skill. Now, if you recognize it as a skill, you would want to incentivize it. Now, so according to me, that's the most important thing, because if there is no incentive for somebody to mediate, and I think we've touched upon it in earlier shows also, then that skill level would also not go up. Why I say that the success rate of mediation is around 30%. Now compare it to the international perspective where you go to UK, Singapore, the mediation success rate is around above 70%. Why is that? Because obviously the main pillar of mediation is the mediator. So therefore, I think if we recognize it as a skill, automatically where you would have programs, diploma, people actually, having, professing mediation as a permanent thing, full day thing. I think that is something which we need to encourage. I don't think it can happen in a day or so, but I think that's the ecosystem we could actually cultivate and we can start. I think that's the one suggestion I would have.
I'm very happy that you say this because of two reasons. Justice Tejas Karya has spoken on this issue, that you incentivize mediation with arbitration similar fees, so that people can do this practice, or devote large amount of time to mediation. Justice Arjun Kumar Sikri, who's a leading arbitrator, also has said the same. So there are important voices in our profession who are sort of lending their voice for mediation, and of course I'd like to discuss this with you later. Thank you for your closing comment. I'll go to Advocate Anirudh Bakru for his good wishes for Justice Suryakant and one suggestion that he would like to submit to him.
Thanks, Tarun. I think the only thing the plan looks good is that maybe if you could get some state government and some government buy-in, especially for disputes which are of service nature. You have so many cases pending where people are fighting for pension, increments. Those, I think, if targeted, could easily be resolved, with some financial midpoint. Labor disputes pertaining to PSUs. If you could have try and look at those disputes that are non-commercial, which actually affect a person who served for 30 years and is now fighting. And those tend to also linger on, compared to commercial disputes, which are under a streamlined procedure. So if you could target those, get some government buy-in there, at least try and resolve those issues. That would, I think, would really help in reducing the pendency.
Advocate Anirudh Bakru
we wish the best. I think all of us are really hopeful for this exercise, and we really hope it turns out as it's supposed to.
Indeed, yes. We hope for the best. And of course, as you suggested, the government should be brought on board for these kind of matters. So even these kind of matters see disposal at a higher rate. Thank you for your closing comment. I'll go to Advocate Siddharth Sharma. And of course, I would also ask you on the tax side, do you have any hope that these issues too can sort of be included in the mediation process and settled quickly? What is your experience, your wishes for Justice Suryakant, and your one suggestion that you would like to give?
Well, as far as the tax aspect is concerned, there are always circulars by the CBDT issued from time to time for settlement of disputes. So that's an entirely different thing. I would not merge it with mediation, because mediation itself is a very broad topic. But one general suggestion I have is that the mediation term should be in vogue, especially looking at the current scenario where even our Prime Minister encourages Make in India. Mediation is as old as the Indian society. That was also said by your lordships. And we have inherited a foreign legal system. It has slowly evolved as per our needs and wants and as per the latest judgments and our requirements from time to time. But if we can also take that and go back to our roots, and we can find out as to how we can make this a very fashionable kind of a thing to go forward to, and find some way to create eagerness in the parties to go forward with mediation, and that same level of enthusiasm as they have to go to courts, I think that will be a very good head start for this kind of an initiative. Thank you.
Indeed, what you are saying is a buy-in from the parties who are to dispute, that they buy that mediation is the thing that will get us result. Indeed, some very good suggestions on today's show, and of course, it's nice that the bar is supporting the judiciary in this initiative, which is heartening to note, and also that Justice Suryakant, and you like it when a judge says that not only will I do my work, I'll publish my report card and tell you what I have done. It is something. It's a very happy thing to learn, and that he communicates, and he's communicating frequently on these issues. And he said that a judge should communicate, which is also very important for us. He says that I'll talk what I'm doing, which is so nice that he wants to keep a conversation going, and the bar also has to respond to it. And this is a good thing. I would like to thank on this note Senior Advocate Shashank Garg, Advocate Shri Venkatesh, Advocate Vivek Jain, Advocate Anirudh Bakru, Advocate Siddharth Sharma. You all spared your time for this very important topic of mediation, joined us today. Appreciate your joining us. Thank you so very much.
Thank you so much, Tarun.
Thank
Have
you.
a nice
Thank you,
evening.
Tarun.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.